Right, having just finished up last week with the Dormant Commerce Clause, we turn to a closely related doctrine that's contained in Article 4 of the Constitution, the Privileges and Immunities Clause. Now, there is also a Privileges and Immunities Clause in the 14th Amendment. So if you go back to Section 1 of the 14th Amendment, which, as we already looked at, contains the substantive provisions of the 14th Amendment that we are not studying in this class, we only looked at Section 5, but if you go back and you look at Section 1 of the 14th Amendment, you'll see that there's reference to privileges or immunities of the citizens of the several states. And that section has a different interpretation than the one that we're going to be looking at. We're looking at the provision contained in Article 4, which is part of the original Constitution, and the Privileges or Immunities Clause. And there is that distinction in wording. Article 4 refers to privileges and immunities, and the 14th Amendment refers to the privileges or immunities. So that's one way to remember the difference. But when you get to Con Law 2 and you look at the 14th Amendment's provision, you will learn that it has a very different set of doctrines associated with it and protections. So we're looking at the Privileges and Immunities Clause of Article 4, closely related, as I said, to the Dormant Commerce Clause. And the first case that we have, the handout, the Baldwin case, references the relationship between these two clauses as stemming from the Articles of Confederation. So let's look at the relevant provision of the Articles of Confederation so that we can get a better sense of this relationship. So here's the relevant provision. It said, "The better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states. And people of each state, the people of each state shall have free ingress and regress to and from any other state, and shall enjoy therein all the privileges of trade and commerce, subject to the same duties, impositions, and restrictions as the inhabitants thereof respectively, provided that such restrictions shall not extend so far as to prevent the removal of property imported into any state to any other state of which the owner is an inhabitant, provided also that no imposition, duties, or restrictions shall be laid by any state on the property of the United States, or either of them." So what is this article? So also Article 4 as the constitutional article that we'll be looking at. So this article and Article 4 of the Constitution are about the relationships, largely they're about the relationships among the states and the rights that the states have vis-a-vis each other, or the rights that the citizens of the states have with respect to the other states' governments. So here in this article, we actually have somewhat of a purpose clause at the very introduction to this clause, the better to secure and perpetuate mutual friendship and intercourse among the people. So that's the reason that this clause exists, to try to allow for friendship among the states. That is, we want to make the states' relationships with each other as smooth as possible, and encourage the people to go from one state to another, encourage the people to have interactions and dealings with the people of different states. With that goal in mind, the free inhabitants of each state, so naturally that excludes slaves, and it also excludes paupers, vagabonds, and fugitives from justice, the free inhabitants of each state shall be entitled to all privileges and immunities of free citizens in the several states. So the idea here being that the inhabitants of one state should be entitled to the privileges and immunities that are given by the states to their own citizens, and the people of each state shall have free ingress and regress to and from any other state. So there should be the ability to travel between the states, and also the ability to enjoy all the privileges of trade and commerce. So this is where the idea of the Dormant Commerce Clause comes from, that the state should not be able to impose any trade or commercial restrictions based merely on the fact that someone is coming to one state from a different state. Right, and except that you should be treated, you should be treated just as someone in another state, not given any privileges, not giving any privileges that the state doesn't give to its own citizens. So the next clause, subject to the same duties, impositions, and restrictions. So if a state imposes duties, impositions, and restrictions on its own citizens, the idea was that as a citizen coming from the outside, you should be treated just the same as anyone else. Of course, there's this next very awkward provision that needs some context. Provided that such restrictions shall not extend so far as to prevent the removal of property imported into any state to any other state of which the owner is an inhabitant. And what property is that clause talking about? That, of course, will be mirrored in the Article 4 provision as well. That is the clause to protect slavery. So if a state prohibited slavery or the owning of slaves, that was the one restriction that they couldn't impose on someone else coming from the outside. All right, so that's the source of the Privileges and Immunities Clause in Article 4, but you should also see it as the source of the Dormant Commerce Clause. And the two ideas being closely related to each other, having the same goal of easy interaction between the states. So Article 4 is what is sometimes called the Interstate Comity Article. That is the article that is attempting to ensure that the states get along with one another. In this article, there are a number of clauses, relevant clauses. The full faith and credit clause being an important one. This clause is largely taken up in a course called Conflict of Laws, which I would encourage you all to take. This is the clause that deals with how states should treat other states' laws. So also under conflict of laws, you would have another doctrine called choice of laws, and other state courts' judgments. So do states have to recognize the court judgments of other states? Do states have to recognize the licenses of other states? The extradition clause, if a criminal is wanted in one state but is presently physically present in another state, how does that one state that wants the prisoner get the individual back from another state? The extradition clause deals with that. Of course, the fugitive slave clause, which was important at the time, dealing with essentially extradition but of property, not individuals. The equal footing doctrine deals with the admission of states to the Union. The idea here is that Congress is required to admit states on an equal footing with all other states, so every state has to have the same rights as every other state. No state could be admitted in some inferior fashion, so there couldn't be some idea as a junior state, or states' rights couldn't vary depending on how long you've been a member of the Union. The guarantee clause, we've already looked at that with respect to the political question doctrine. This is the clause that guarantees to each state a republican form of government. The privileges and immunities clause is contained in Section 2. This is the exact language. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. And the two cases that we'll look at will unpack the meaning of that clause. So what is the relationship between the Dormant Commerce Clause doctrine that we've already looked at and this new clause? So both clauses, or both doctrines, have the goal of protecting citizens from discrimination by other states because they are citizens of different states. So to protect against state A from imposing some different law or denying someone some right because they're not a citizen of state A, they're a citizen of state B. So both doctrines are concerned with preventing discrimination based upon state residency. There are some important differences, though. One important difference is that the court will tell us that the plaintiff in a privileges and immunities claim must be an out-of-stater. Because here here we're dealing with what is essentially an individual right. It's a right to be treated the same as a state treats its own citizens. And therefore, in order to have standing, the court has said that the plaintiff must be an out-of-stater because the right belongs to someone not a resident of the state that the claim is against. Now, this is one of the clauses, one of the very few places where the Constitution references citizenship. The language of the clause is the citizens of each state shall be entitled to the privileges and immunities of the citizens in the several state. And the court has taken that term literally, that only U.S. citizens have privileges and immunities right. And this also means that only people, human beings, can be victims of privileges and immunities violations. So corporations cannot sue for a violation of the Privileges and Immunities Clause, and no non-U.S. citizens can sue either. When you get to the study of the 14th Amendment in Con Law 2, you'll see that the court applies the same restriction to the 14th Amendment's provision because it's worded the same, but the most important clauses of the 14th Amendment, the Due Process and the Equal Protection Clause, explicitly use the word person rather than citizen. So those clauses get applied far more broadly than the Privileges and Immunities Clause. Another major difference is that there are no exceptions to privileges and immunities violations. So we saw with the Dormant Commerce Clause that Congress could approve state legislation that would otherwise be a violation of the Dormant Commerce Clause, and states could engage in what looked like discrimination so long as they were not acting as a sovereign, but instead were acting as a market participant. Neither exception would apply to the Privileges and Immunities Clause. So following the Chemerinsky outline, I think it's a useful way to conceive of what's going on here, what the doctrine will look like. There are two basic questions that we need to determine whether or not there's been a Privileges and Immunities Clause violation. We ask, has the state discriminated against out-of-staters with regard to the privileges and immunities that it accords its own citizens? In other words, is there disparate, uneven treatment? Is a state's own citizens getting some special right that an out-of-stater is not getting? And if the answer to that question is yes, the question becomes, is there a sufficient justification for the discrimination? So the questions that the doctrine doesn't give us clear answers to, or that require sort of ad hoc argumentation, are actually some very important questions. So what exactly are privileges and immunities? If we identify state discrimination, how do we know that that discrimination is with regard to a privilege and immunity? And then second, with regard to the second question, what exactly counts as a sufficient justification for the discrimination? So let's see if the cases give us any clues as to those two questions about what exactly constitutes a privilege and immunity, and if the state is caught to be discriminating, what counts as a sufficient justification. All right, so the first case that we have is Baldwin versus Fish and Game Commission of Montana. So one of the things that Montanans like to do is hunt elk, but it's not just Montanans that want to do this. It is also residents from other states. So as you can see, the facts tell us on the first page that appellant Lester Baldwin is a Montana resident. He's also an outfitter who holds a state license as a hunting guide, and a majority of his customers, and you can see some of their names there, Carson, Hughesby, Lee, and Morris, are residents of a different state, in this case Minnesota. So given the limitations that I explained just a moment ago on the Privileges and Immunities Clause, a question that should arise as you're looking at this set of facts is, why does Baldwin have standing? Baldwin is a Montana resident, and he's challenging a Montana law for violating the Privileges and Immunities Clause. I just said that you must be an out-of-state citizen to have a right, a Privileges and Immunities right against a different state. And I would urge you to go and look at the full opinion if you want to see the explanation of the standing. But essentially here, Baldwin is invoking third-party standing, suing on behalf of the rights of his customers. All right. So, and you can do the full standing analysis in your head. He would still need his own injury, but the legal right. He needs injury in fact, but the legal injury would be the Minnesota resident's legal injury. All right. So, what is the discrimination that's at issue here? So, the discrimination is the differential fees that are charged out-of-state residents versus in-state residents with respect to a hunting license for elk in particular. You can see the prices fluctuate each year, but in 1975, a Montana resident could purchase a license solely for elk for $4. However, a non-resident was required to spend $151 for a set of licenses. And then 1976, an elk tag in Montana was only $9 for in-state residents, but $225 for a non-resident who had to buy a package of licenses. And as the court explains, the difference is 7.5 times the in-state fee. And if the person from out of state just wants to hunt elk, then it's 25 times as much. He's paying 25 times as much to get the same privilege that the in-state citizen has. So what else do we know? What facts does the court give us? On page 2, we see that the court mentions that Montana, the hunting of elk has grown in popularity. There's been an increase in 530% for non-residents. We're also told that elk management is expensive. One of the reasons the state has been so successful is that it has expended a lot of its own resources at elk management. And we're also told that Montana has more than 400 outfitters who equip and guide hunting parties. And the state has a force of 70 game wardens. So that's all as background. So the claim is stated at the top of page 3 that this price differential of 7.5 to 1 cannot be justified, and therefore the discrimination here is an unconstitutional violation of the Privileges and Immunities Clause. So is that the case here? To go back to our question, we are asking two questions. How is the state discriminated against out-of-staters with regard to the privileges and immunities that it accords its own citizens? So clearly there's some discrimination going on here between Montana's own citizens and the way it treats out-of-state citizens. And the question then is elk hunting a privilege and immunity that is protected by Article 4? So the court tells us in Part 4 of its opinion, starting on page 3, that this is one of those clauses of the Constitution that hasn't received much interpretation. The court expressly links the clause to the Articles of Confederation Clause, points out the similarity with the Dormant Commerce Clause, and then it says there are 3 cases that we can refer to in helping to determine what is a privilege and immunity that is protected by that clause. The court starts out by quoting an excerpt from Justice Field's decision from 1869 in Paul versus Virginia, then a decision from sometime later in 1939, the Hague case from Justice Roberts, and then which at this time would have been a more recent case, 1975, Austin versus New Hampshire, written by Justice Marshall. So what do we learn from each of those cases? So Justice Field talks about the clause as ensuring, there's an equal footing aspect to it, that the citizens of the various states should be upon equal footing with each other when they go to another state. bottom of page 3, it ensures to them in other states the same freedom possessed by the citizens in those states in the acquisition and enjoyment of property and in the pursuit of happiness. So the Field decision then essentially talks about the equality of treatment, specifically singles out the enjoyment of property. Then what about the 1939 opinion? Justice Roberts says that in any state, every citizen of any other state is to have the same privileges and immunities which the citizens of that state enjoy. The section, in effect, prevents a state from discriminating against citizens of other states in favor of its own. So there it's basically a non-discrimination provision, but not a substantive provision that accords certain rights. And then the Austin versus New Hampshire opinion, Justice Marshall talks about the requirement of equality of treatment. So he says the clause establishes a norm of comity without specifying the particular subjects as to which citizens of one state coming within the jurisdiction of another are guaranteed equality of treatment. So it's an equality provision, but what these three opinions have in common is, so they all agree that this is an equality provision, but they also seem to also agree that it doesn't have any substance to it. In other words, the substance is left up to the states. So whatever privileges and immunities the states want to accord their own citizens, it's those state-determined privileges and immunities that they must accord out-of-state citizens. But in and of itself, someone is not going to be heard to claim a privileges and immunities violation if a state doesn't allow them to do something, if the state doesn't allow its own citizens to do something. So let's say that we have state A and citizen from state B. And a citizen from state B, let's say, is allowed to hunt 3 elk a year in his own state, and then he goes to state A, and state A doesn't allow any hunting at all. The person wouldn't be heard to claim discrimination because he couldn't hunt in state A, just because he could do that in his own state, right? So it's a mere procedural requirement of equality, but it doesn't say what the substance of the equality has to be about. All right, but we're still left with the question, so just because a state allows its own citizens to do something, does that mean that it has to always allow out-of-staters to do the same thing? So if we go to page 5, we see the court citing some other precedent that discusses the traditional subjects of the equality concerns. So here, the court discusses the pursuit of common callings. Top of page 5. Unreasonable burdens on citizens of other state in the pursuit of their common callings, in the ownership and the disposition of privately held property within the state, and in access to the state courts. So those three things seem to come up over and over in the few cases that the court has decided on privileges and immunities grounds. That is, the right to engage in what the court in the 19th century called a common calling. This would essentially be an occupation, right? The right to go to another state to work, the right to hold property in another state, and the court tells us the access to the courts of another state. But then if we look at the next paragraph on page 5, we see that the court explains that this equality of treatment doesn't have to run the gamut. It doesn't have to be with every single aspect of state treatment. And in fact, 2 major exceptions are listed here, what we might call political exceptions. Voting and office holding. So we know just from common practice that states can impose requirements, residency requirements, on the right to vote and the right to hold office in a state. And there's no suggestion here. The court explains that they've frequently held that the Privileges and Immunities Clause is not violated by these limitations, by these preferences for state citizenship. Right? And why is that the case? Why can these be exempted? So the court says, in that same paragraph, near the end, some distinctions between residents and non-residents merely reflect the fact that this is a nation composed of individual states and are permitted. Other distinctions are prohibited because they hinder the formation, the purpose, or the development of a single union. So if the distinction, a distinction, a discrimination is permitted if it is merely a recognition that the nation is composed of individual states, but it would be prohibited if the discrimination goes to the formation, the purpose, or the development of this single of the nation as a single union. Right. So the idea, it appears, with the exceptions, the voting and the elective office holding exception, those voting and elective office holding state officers are necessary to the identity of the state. Right. The state needs to be able to set up its own government. It needs to be able to staff that government and to choose that government. And therefore, the staffing and the selection process can be limited to those people that are going to be most affected by it, the people who live there. Right, but the pursuit of common callings deals with the ability to engage with other states, the ability to move from one state to another, those and the ability to access the courts, the ability to hold property. Those rights, those privileges and immunities go to, the court says, the very idea of a single nation. Now, there's this case, bottom of page 5, Corfield versus Coriel. Not a Supreme Court case, but a case written by a Supreme Court justice during the period in the 19th century when Supreme Court justices rode circuit. So this case, written by a Supreme Court justice, lists, this is Justice Bushrod Washington, lists the rights that he thinks are going to be most commonly brought under the head of privileges and immunities. And you can see those listed at the bottom of page 5. But it's not an exhaustive list. And as I mentioned, it's generally going to be up to the states as to which privileges and immunities they grant to their own citizens, and therefore which ones they're going to have to accord to other out-of-state residents. All right, so is elk hunting, is the ability to hunt elk at a certain price one of the privileges and immunities of citizenship? And the test, the best that we can do with a test here is that part quoted in the middle of page 5. So how are we going to know whether something is a privilege or immunity where the state must accord equal treatment? It's going to be only with respect to those things bearing upon the vitality of the nation as a single entity. Must the state treat all citizens, resident and non-resident, equally? So, is equality in access to elk such a privilege? Now, before the court answers that question, on page 6, it goes through some of its cases dealing with the state management of wildlife. And the court explains that there are cases that seem to be all over the map about the state's ability to manage wildlife. There have been certainly limits on it, and we've read at least a couple of the cases that put limits on that ability. The middle of page 6, you can see Klepp versus New Mexico, right? The states can't claim wildlife management privileges in the face of a superior federal statute. And then Missouri versus Holland, same thing. The Klepp statute was passed in virtue of Congress's property clause power, which is also here in Article 4. And the statute in Missouri versus Holland was passed pursuant to Congress's treaty-making power. But the court says that just because sometimes these the abilities to manage a state's own resources must yield to superior federal interest, that doesn't mean that the states don't have certain independent abilities to regulate their natural resources. And if we look at the bottom of page 6, one case that's offered as a reason that Baldwin should win is this case Toomer versus Whitesell from 1948, where the court struck down a South Carolina statute requiring non-residents of the state to pay a $2,500 licensing fee to operate a commercial shrimp boat, whereas residents only had to pay $25. Right? And so the argument that Baldwin wants to make is this case is just like that. To fish for shrimp in South Carolina, the court required equality of treatment, and here, essentially, this is the same thing, hunting for elk. But the court says, no, there's a big difference between this case and that case. The South Carolina statute went to a restriction on the ability to engage in a commercial activity, right? The important word there being a commercial shrimp boat, not a recreational activity. And the court says that is an important distinction here, that the elk that are being hunted here, one of the things the court pointed out in the facts at the beginning of the case is that elk are not hunted for commercial purposes. It's merely a recreational activity. So the South Carolina statute went to the heart of the Privileges and Immunities Clause by discriminating against the pursuit of common callings, whereas here the same thing can't be said. So over to page 7, is this an interference with the Privileges and Immunities Clause? Does elk hunting bear upon the vitality of the nation as a single entity? And the court says, the middle of page 7, merely to ask the question seems to provide the answer. Now, that's not much of an analysis. It's almost an argument that appeals to the obviousness of the triviality that appears to be on the face of the question. That, of course, elk hunting is not something that is vitally important to national harmony, the way that the ability to work in a state or to hold property in a state or to access a state's courts would be. So perhaps that's why we don't need much analysis here. All the court says is that this is a recreation and a sport. It is not a means to a resident's livelihood. Equality in access to Montana elk is not basic to the maintenance or the well-being of the Union. And therefore, the court gets away with this last line: whatever rights or activities may be fundamental under the Privileges and Immunities Clause, we are persuaded and hold that elk hunting by non-residents in Montana is not one of them. So one rule that we can pull out here then, besides this test about what needs to be said in order for something to be a privilege and immunity, is that the court also uses this word fundamental, that the Privileges and Immunities Clause of Article 4 essentially protects fundamental rights, but fundamental rights in the sense that they're rights that the state accords its own citizens, so they're not rights that would be independently required to be offered by a state. And the reason that using that word fundamental can be problematic is when you get to Con Law 2, you'll see the court calling fundamental rights, or using the word fundamental rights to mean something completely different. Their fundamental rights, when you get to the Due Process Clause, will mean rights that states must offer to their citizens. But here, the right is fundamental only in the sense that the state is choosing to offer something to its own citizens that is fundamental and therefore must be offered on equal terms to out-of-staters. But it's not fundamental in the sense that if the state didn't offer it, it must offer it. Right? So I think we would be able to you could see that. Suppose a state didn't offer elk hunting at all. No one would be claiming that the state had to offer it. And here, just because Montana offers this ability at a lower price to its own residents than out-of-state residents, the court is saying this is not one of those fundamental rights. So the court upholds the Montana statute then because this is not a privilege and immunity that is accorded any protection under the Article 4 clause. There's a dissent here, a short excerpt of a dissent written by Justice Brennan, and Justice Brennan says that his main critique of the majority opinion is the court's focus, and really it's that test there. The test here that the majority offers focuses upon the right that is being asserted by the plaintiff. So in this case, just the very question, is elk hunting something that's protected by the Privileges and Immunities Clause? Justice Brennan says, I think that's the wrong question to ask. The question shouldn't focus on the thing that is the source of the discriminatory treatment. The question should focus on the state's rationale for why it is engaging in the discriminatory treatment, regardless of what the item is. So the majority focuses on the thing that is the subject of the discriminatory treatment. The dissent would focus on the rationale, regardless of what the thing is. So turning to the rationale, Justice Brennan says that the state puts up two different justifications. And notice the majority doesn't go through this because they don't even find the clause applicable. But Justice Brennan goes through the justifications that the state offers. They offer two, conservation and costs. The conservation argument seems sensible enough that Montana wants to make sure that the elk are well managed and they don't want them overhunted. And therefore, a high price might be a way to dissuade people from who otherwise would come into Montana to hunt elk from coming in at all because they don't want to pay the high price. But Justice Brennan says that Montana, well, with both of these, and so how does the cost argument work? The cost argument is that people from out of state require more supervision, more policing, so they have 70 game wardens, and they need to pay for those, and you have more people in state, you need more oversight, and therefore that raises the cost to the state itself. And with regard to both arguments, Justice Brennan's point is essentially that the state should be held to its proof. And Justice Brennan says he doesn't see any actual proof in the record. He says there's no evidence that out-of-staters pose a unique problem to overhunting. And even if there was such proof, he thinks that Montana would need to offer an argument that it had tried a non-discriminatory alternative in the first place, like discouraging its own residents to overhunt elk, if overhunting is indeed a problem, which Justice Brennan doesn't think the state has shown. And then with respect to the cost, Justice Brennan says that he wouldn't say that there can be absolutely no discrimination or no differential treatment in cost, but he says that the state should have to justify the 7.5 to 1 ratio. Do out-of-staters really cost 7.5 times as much to the state as in-staters do? In other words, the state government should have to show its work in how it gets to those different prices. But the majority doesn't engage in that sort of analysis because it finds the clause not even applicable, because it stops the analysis when it asks, is elk hunting a privilege and immunity that requires constitutional inquiry? All right. So what about the next case, which is in the case book, the Supreme Court of New Hampshire versus Piper. So here we have a New Hampshire Supreme Court rule that requires state residency to be a member of the bar. So we can see here Piper lived in Vermont, but just over the border, only 400 yards from the New Hampshire border. She applied to take the New Hampshire bar in February 1980. She passed the moral character test. She passed the examination, but she was told that if she wanted to be admitted, she would have to have an address in the state of New Hampshire. So the question is, so what's the discriminatory treatment here? The discriminatory treatment is bar admissions. So using the test that we saw in the Baldwin case, is the practice of law a protected privilege? Or, as the court phrases it in the middle of page 381, is the practice of law a fundamental right within the meaning of Baldwin versus Montana Fish and Game Commission? So the court essentially says yes. On page 382, the court says yes, for both economic or commercial and non-commercial reasons, the Baldwin test is met. So one of the historic privileges and immunities that had been protected was the right to engage in a common calling. So this is effectively telling people that they can't practice law in New Hampshire unless they're New Hampshire residents. And so that seems the sort of classic discrimination that the Privileges and Immunities Clause was designed to prohibit. The other non-economic reason that the court offers here as to why this should be protected by the Privileges and Immunities Clause, bottom of page 382, the court says, we believe that the legal profession has a non-commercial role and duty that reinforce the view that the practice of law falls within the ambit of the Privileges and Immunities Clause. And what is that non-commercial role and duty? Well, the court says out-of-state lawyers may and often do represent persons who raise unpopular federal claims. So this would be the idea that sometimes an out-of-state lawyer would serve the benefit of seeking justice better than an in-state lawyer. So the court says, yes, this should be subject to scrutiny under the Privileges and Immunities Clause. What about an exception, the political exceptions that the court had noted? So if there's been a history of protecting equal access to common callings, there was that exception for voting and state office holding. And one argument that New Hampshire tries to make here is that the practice of law is more like office holding than it is like a regular job, than it is like shrimp fishing, right? So if precedent says that a state can say the election of state judges is limited to state residents, isn't the practice of law more like that than it is like shrimp fishing? And the court says no. Well, and one of New Hampshire's other arguments is that lawyers are often referred to as officers of the court. So isn't that an argument that the state views lawyers as closer to elected officials than it does to a run-of-the-mill job? And the court says no, that when lawyers are referred to as officers of the court, that's more a term of art. The court says a lawyer is not an officer of the state in any political sense, right? So the court discounts this argument that the political exceptions should apply to the job of lawyer. So we have a situation then, unlike the Baldwin case, where the Privileges and Immunities Clause should apply because we have what the court calls a fundamental right that's involved here. So part 3 of the opinion on page 383 is where the court engages in the analysis. And this is essentially a strict scrutiny analysis, the sort of analysis that we saw the court engaging in last week when the court found a discriminatory state statute under the Dormant Commerce Clause. So here the state is going to be required to show that they have substantial interests that are at stake here, and that the statute is the only way that those interests can be served. In other words, the state can't accomplish these same substantial interests with a non-discriminatory statute. So what are the state's interests here? Well, first of all, just at the bottom of page 383, you can see that test set out there, that strict scrutiny test. There must be a substantial reason for the difference in treatment, and the discrimination practiced against non-residents must bear a substantial relationship to the state's objective. So the justifications appear at the top of page 384. So remember, Justice Brennan in Baldwin wanted to look at the justifications right away as the first thing he wanted to look at. But the court has kept with that Baldwin analysis, and it looks to the right first, must determine that it's fundamental before it gets to the state's reasons. So what are the state's justifications? There are 4 of them that are listed at the top. New Hampshire says we must have this rule that limits bar membership to state residents because state residents are the ones who are likely to become and remain familiar with local rules and procedures, to behave ethically, to be available for state court proceedings, and to do pro bono and other volunteer work in the state. And the court essentially goes through all 4 and rejects them as being substantial. So the court says that, they reject them as, so if you go back to that test that's at the bottom of 383, they reject the idea that there's a substantial relationship between the rules and the state's objective, right? So if you look at the the first one, becoming familiar with local rules and procedures. The court says there's no reason to believe that you would need state residency in order to do that. Same with behaving ethically. There are ways that the state bar, the state Supreme Court, could enforce these rules against non-residents as well. They could force them to do continuing legal education on the state's ethics rules or the state's procedures, and there's no reason that out-of-staters couldn't do that just as well as in-staters. With regards to being available for court proceedings, the court gives an example of some differential treatment that would be permissible, that would be less discriminatory than the rule that they have now. They say that, as they say, the state can protect its interests through less restrictive means, such as a rule that all out-of-state lawyers, all out-of-state New Hampshire bar members must retain local counsel to file matters quickly. Right? And then the last point, to do pro bono or volunteer work. Again, the state could merely require that as some states do, as something that must be met in order to keep your law license. You must do a certain number of hours of pro bono work, and if that's made a requirement, then there's no reason that an out-of-stater couldn't be held to meet that, just as an in-stater could. And notice that the court says at the bottom of page 384 in the footnotes a couple of things here. And this is, so in answering the question, is the discriminatory law substantially related to the problems posed by out-of-state lawyers? And the court says no. So this is the sort of analysis that you will be doing far more frequently in constitutional law too. But let's see if you can start to wrap your mind around what's going on here. And the same was true with the analysis that was given in the Dormant Commerce Clause realm. The idea here of, if you go to footnote 19, the court talks about over-inclusiveness and under-inclusiveness. And it says that both problems, so over-inclusiveness and under-inclusiveness, are problems about the fit between the means and the ends, the fit between the stated justifications, those four things that are at the top of page 384, and then the way that the means, the way that the law actually works here. So it's over-inclusive. So let's take an example. So let's take the example of behaving ethically. We would say that that is both over and under inclusive. So acknowledging that the state has an interest in making sure that its bar behaves ethically, the way that the state chose to enforce that requirement, that lawyers behave ethically, was to say no out-of-staters can be lawyers. Why is that both over and under inclusive? It's over inclusive because it's going to cover more ground than it needs to. Everyone would agree that there are plenty of ethical out-of-state lawyers, but they're kicked out of the bar, right? It's under-inclusive, however, because everyone would also acknowledge that there are going to be some in-state lawyers that behave unethically. And so in that sense, it's under-inclusive. So it covers both too much ground and not enough ground. It's a bad way, it's a bad means to meet the end here, the end being to have an ethical bar. And what the court is concerned about is when it sees all, and you could do that same analysis for each of these things here, for each of the stated reasons. And the court's concern is that when you have a statute that seems both over and under inclusive with respect to the stated justifications, the court starts to suspect that there's a different reason that is actually motivating the statute, right? Because when you have a statute that is both over and under inclusive, you start to think, boy, it's difficult to imagine that the state legislature really missed the mark that much. I mean, they really must not know how to legislate. They really must not know how to write a statute that meets their goals. Instead, the better explanation is that they probably had some unstated goal. And the feared unstated goal here is, look at footnote 18. A former president of the ABA suggested another possible reason for the rule. Many of the states have erected fences against out-of-state lawyers. Many of states that have erected fences against out-of-state lawyers have done so primarily to protect their own lawyers from professional competition, right? And that's probably the real unstated concern here, is that New Hampshire has passed a protectionist piece of legislation, right? The same rationale that would be prohibited under the Dormant Commerce Clause is also prohibited here. Just protecting your in-state workers from out-of-state competition is never going to be a permissible state interest. So the rule gets struck down then as a violation of the Privileges and Immunities Clause. Right. Justice Rehnquist has, we get a fairly lengthy dissent by Justice Rehnquist here starting on page 386. Justice Rehnquist is critical of this least restrictive means analysis. He suggests that there should be more attention to federalism here, that law is special. Justice Rehnquist thinks law shouldn't be treated, the practice of law, that is, shouldn't be treated as just any other profession. He says, after all, how would we then, so if we take the majority's rule in Supreme Court versus Piper, how do we then justify something like having differential bar exams? What reason would there be for someone who's admitted to practice in one state not being able to practice in another state? So Justice Rehnquist's point is we already recognize that the states have reasons for treating out-of-staters differently, but maybe those could all be justified in some other way. It's not really a differential treatment with respect to out-of-staters. It's differential treatments with respect to who has taken and passed this particular examination. All right, so there's a lot there in the in Justice Rehnquist's dissent. He thinks that there are some good logical arguments for the state's limitation, including he thinks that the majority doesn't appreciate the civic role that lawyers play, but I will let you study that opinion in more detail on your own. So whenever you have a Privileges and Immunities Clause claim, the first thing you're going to want to do, because of the test that the court has set out in Baldwin, is you're going to want to put it into one of two categories. Is it a fundamental or a non-fundamental privilege and immunity, privilege or immunity? Is it a fundamental or a non-fundamental right, would be another way to ask the question. Is it more like elk hunting? Is it a mere recreational, non-commercial activity? Is it something that you can conclude through some argumentation that it's not necessary that equality occur to promote interstate harmony? Or is it a fundamental right? Is it restricting doing business on equal terms? Or is there some other reason, like the reason given in the Piper case, that champions of unpopular causes can come more easily from out of state? Is there some, if it's not arguable, or if it's not only arguable on one of these broader categories of doing business on equal terms or owning property on equal terms or having access to the state's courts, is there some other unique argument that could be made for why the states must treat out-of-state citizens the same way that they treat their in-state citizens with respect to whatever the source of the discrimination is? All right, there's a good problem on the last page, page 10 of the handout, looking at one of the court's most recent Privileges and Immunities decision. I think I gave you the citation there, so I will let you work through that problem there on your own, but I would highly recommend looking at that.